Thanks very much for joining us. In our first story, the Supreme Court has ruled that all criminal offences in the country's statute books must be bailable.
The landmark decision is set to give alleged rapists, murderers, pirates and armed robbers, among others, the opportunity to be given bail by the courts.
The highest court by a 5-2 majority declared Section 97, Subsection 7 of the Criminal Procedure and Juvenile Justice Act, Act 30, unconstitutional and accordingly struck it out from the statutes. Consequent to the decision, all courts that have jurisdiction to try and hear cases such as murder, rape, treason, piracy, defilement, and narcotics will from Thursday, May 5, have the jurisdiction to grant bail in those cases. Prior to the decision by the court, such cases were deemed non-bailable, except in a few circumstances, such as when there is unreasonable delays in the trial or when the facts of the case do not support the charges. Thursday's ruling is likely to open the floodgate for accused persons whose cases are being tried and languishing in remand to initiate bail applications. The Supreme Court made the ruling in a case titled Martin Kpebu versus Attorney General, filed in February 2015.
Right, so let's get on the phone lines now and speak to lawyer Professor Ken Atefua. He was one of the lead lawyers handling this case. Thank you very much, sir, for your time. First of all, how do you feel about this ruling?
Oh, I feel thrilled. I'm highly elated. Good evening to your listeners. It's a very pleasant day for us. And I congratulate my friend and my learned friend and lawyer, Martin Kpebu, for doing an excellent job. My client was solid. We prepared a very solid case. It was vigorously.
Hello, Prof?
Yes, hello.
Great, go ahead.
Yes, I was saying that, we presented a solid case. It took a long while. It was vigorously opposed, very vehemently opposed by the Attorney General. But at the end of the day, the majority of the Supreme Court agreed with us that the so-called non-bailable offences provision, Section 96(7) of Act 30, the Criminal and Other Offences Procedure Act, is unconstitutional. And even the minority that dissented, the fundamental effect of their opinion is that the law is all right, and it is the interpretation that some judges have given to the wrong interpretation that some judges have given to that provision that has led to the mischief, and that the law itself was okay, and the judges were at liberty to, as it were, consider the circumstances of each bail application and to exercise their discretion whether to grant bail or not to grant bail. Now, either way, it seems to us that the effect is the same. The Supreme Court has effectively struck down this offending provision that is completely unconstitutional. We are highly elated by that ruling.
So this essentially appears to be a landmark ruling, considering how long this has been on our statute books. But some have also expressed concerns that this is likely to escalate tension and put the lives of informants at risk.
Oh, absolutely not. I don't see how. How does the unconstitutionality, the declaration by the court that this is unconstitutional, jeopardize the lives of informants? You see, if we took policing and investigation seriously in this country, half the lives we waste in our prisons and much of the money we waste on people that we incarcerate wrongfully would be saved, would be avoided. If police officers get a case and go beyond merely opening, doing a caution statement, investigation caution statement, and actually do a thorough investigation before going to apprehend the people, we would save a lot of lives. We would win a lot of cases. In other jurisdictions, before they come to effect your arrest and to restrict your liberties, they would have done a thorough investigation, have more or less a watertight case against you, and say, and when they say, Mr. X, I'm placing you under arrest for the murder of Miss Y, they would be on terra firma, on solid ground. Now, in this country, by and large, the tendency is to go on allegation and to behave as if the mere fact that allegation is made, it constitutes the proven fact, and then to arrest the person against whom the allegation is made and behave as if that person would flee or evaporate into thin air the next moment unless they are incarcerated. And the tendency is further to do any and everything that can be done to prevent a suspect from seeing the light of day in terms of getting justice. It is as if those who allege are always right, and it is wrong. And so if investigators who do an honest job of investigating, we who are human rights advocates, we are for the rights of victims as well as of suspects. And all we are saying is that our law, Article 15 of our Constitution, guarantees the dignity of all persons. And so does Article 19, that a person shall not be denied their right, their liberties, unless it is for just cause. And what we are saying is that half the time, the detention of people on the grounds that bail has been denied them is unjustified if it is grounded on Section 96(7). And that is all we are saying. Because
my very final question, Prof, before I let you go, if the specific ruling does not take away the right of judges to exercise their discretion and will allow them to take each case by its merit, then what's the excitement here?
No, the law, the ruling. I haven't had a reading of the ruling itself, but the court simply said that in every instance where an application for bail is made, a judge must listen. It does not matter. The so-called non-bailable offenses, they are no longer, it's no longer valid to call anything non-bailable, regardless of the crime that is alleged or charged. Listen to the application for bail and exercise your discretion, and where you think that bail should be granted, set such conditions as you consider appropriate and necessary in the circumstances to guarantee the appearance of the accused in court. Because after all, what is the essence of the whole bail and detention? The bail is to ensure that the person enjoys their liberty, but the person is also available to stand trial. If the court has reason to believe that they will run away, the court will not grant bail, or that they will interfere with the investigation.
Great.
The court will not grant bail.
Great. Thank you very much, Professor Ken Atefo, one of the lead lawyers in this landmark ruling case.